Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. We are going to discuss another 498A harassment or cruelty towards a married woman case, wherein once again the Honorable Supreme Court of India quashed the FIR under Section 498A, alleging that the allegations are far-fetched. The allegations are far-fetched and the allegations are vague allegations. That's why nowadays the use of 498A is leading to the misnomer that women for revenge they are putting all these 498 cases. I don't say all of them are like that, but most of them are like that. Therefore, it has been generalized. You know the very famous case of, what is that? 2014 case, Arnesh Kumar versus State of Bihar. 2014 case where the mechanical arrest is not allowed, and even though the arrest should be there, yes, you use the provisions of Section 41A CRPC. Give him a notice, and if you are satisfied that he will come, don't arrest him. That is the stage. Once again, such type of case has surfaced. You can read the case as Abhishek versus State of Madhya Pradesh, 2023. Criminal Appeal number 1457 by 2015, decided on 31st August 2023 by 3 judges bench. Justice Anirudh Bose, Justice Sanjay Kumar, and Justice S.V.N. Bhatti. S.V.N. Bhatti is, no doubt, he is from Mysore, but he is an Andhra man. Right. So you can read the cases Abhishek versus State of Madhya Pradesh. In this case, the Honorable Supreme Court of India noted that the allegations are impossible. Previously, I used the words far-fetched. I used the words vague allegations. Here, they say that they are impossible and the allegations are inconsistent. Right? Because the allegations particularly against the mother-in-law and brothers-in-law, they are actually, these people, they have resided in different places in India, in the different cities, and the interaction with the family members, with their mother or father, is only during the festive occasions or festive seasons. That's all. They did not goad or they did not abet the persons to harass the so-called particular woman. And the important point is that the woman left the maternal house in the year 2009, I think. The marriage took place in the year 2007, and she left the maternal house in the 2007 and 9, and she is staying with her parents. By now, you might have understood. But anyway, let us discuss the material facts of the case. The factual matrix is like this. The woman's name is Bhavana. Bhavana, she married Mr. Manish, who is the brother of Abhishek. Manish on 2/7/2007 in Indore. The marriage was performed as per Hindu rites and customs at Indore. Actually, by the time of the marriage, the victim or the complainant, she was working as a teacher, and the so-called Nimish, husband, he is working in some cinema field like editor in Bombay. So she has to move to Bombay. So actually in Bombay, differences cropped up between them, and she left Nimish in 2009. Right? This is one part. And vexed with her attitude, and she did not come back, he filed a petition for divorce on 8/5/2013. He filed the divorce petition. Now, the entire revelations came. Actually, 3 months prior to the filing of divorce petition, that is on 5/2/2013, she filed a complaint against the husband, say 498, harassment for additional dowry. So, an FIR in crime number 56/2013 under section 498A IPC and also section 3 and 4 of the Dowry Prohibition Act 1961, they were registered. Of course, these people, they applied for the anticipatory bail. They got the anticipatory bail on 6/3/2013. That is after 1 month, they got the anticipatory bail. Right. And the so-called brothers like Abhishek, they went for the quashment of the FIR under section 482 CRPC. So, in the meantime, the police completed the investigation, they filed the charge sheet. So, here the important point is whether the FIR can be quashed even after the charge sheet or not. The Supreme Court said yes. Normally, when once the case is charged, the court will not take initiative for quashment, but here it happened. Why? Because of the omnibus, because of the vague, because of the far-fetched, because of the inconsistent, because of the impossible incidents, allegations I can say. Right. So, the reasons given by the Supreme Court are like this. So, the charge sheet says that husband, brother-in-laws and mother-in-law, they harassed her for a dowry, that is for additional dowry. Number one. Number two, they used wrong or unparliamentary language. In her language, they are all intolerable words. Then, when she was wearing a nightie while applying some color dye or hair dye, the mother-in-law chided her. You dirty woman, go and dance in the streets with this dirty dress. And brother-in-law asked her for a car to his brother or 2 lakhs cash. And even though she was staying in the mother-in-law's house, she was treated as a paying guest, that's all. So, and the mother-in-law took away her jewelry. These are the allegations by the so-called complaint in the particular case. These are all, they could not be put to strict proof. They are only vague allegations. They are omnibus allegations. So, there no proof, no strict proof. And the relatives visited only during the festival time and no specific days were mentioned. So, allegations are totally insufficient to prove the case of 498A. They do not make out a case of 498A. Quash. So, once again, another quashment 498A case. So, what I mean to say is, no doubt I don't want to advise to book any false case, but before filing a case of 498A, you must be able to mention the periods, the time. If it is dates, okay, it's okay. But normally, the villagers, they do not remember the date. They say, during the festival of Sankranti, during Dasara, like that they will be telling. So, at least that also should be mentioned. Otherwise, same thing will happen. Right, anyway, already 8 minutes are over. So please read the case law and enrich your legal knowledge. Thank you.